In this video, we'll discuss the role of religions in schools in the United States. Religion is very personal. It can be emotionally charged. There have been a lot of controversies over religion issues in schools. Let's look at the first 16 words of the First Amendment to the U.S. Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The first clause is called the Establishment Clause. It requires neutrality from government, including state legislative bodies, school employees, and school boards. The Establishment Clause also prohibits public school advancement of religion. The second clause is called the Free Exercise Clause. It prohibits school officials from interfering with religious expression. The problem is that enforcing one clause often seems to violate the other clause. The Free Exercise Clause establishes people's right to religious expression. Is it possible that your religious expression, if you are religious, violates the Establishment Clause, which requires school employees to be neutral and not to advance a religion? Another complicating factor is that legal scholars, federal judges, and U.S. Supreme Court justices often disagree on when to apply which clause in public schools. Here is some history of the U.S. Constitution and the First Amendment. Many of the framers of the Constitution were very religious men. It was a religiously diverse group when the framers met at the Constitutional Convention to draft a constitution in 1787. The framers of the Constitution favored a neutrality toward religion. The first three words of the Constitution suggest that the rights come from we, the people. Article 6, Clause 3 of the U.S. Constitution reads, "No religion tests shall ever be required as a qualification to any office or public trust under the United States." The First Amendment is one of the 10 amendments that constitute the Bill of Rights. Initially, the First Amendment applied only to the laws enacted by the Congress. In 1925, the Supreme Court applied the First Amendment to states through the Due Process Clause of the 14th Amendment. The 14th Amendment was ratified in 1866 after the Civil War. The 14th Amendment denied states the right to deprive any person of life, liberty, or property without due process of law. It also guaranteed all citizens equal protection of the laws. The purpose of the 14th Amendment was to protect citizens by applying the protection of the Bill of Rights to state action. The amendment also shaped the relationship between religion and public schools. The principle used by the U.S. Supreme Court and federal courts is not whether some religion expression in public school is permissible. The key is whether there is some compelling reason why it is not permissible. Let's look at some landmark U.S. Supreme Court decisions regarding religion in public schools. The first case we're looking at here is Engel versus Vitale. A school board directed school principals to say a prayer aloud by each class in the presence of a teacher at the beginning of each school day. The prayer you see on the screen was required by the school board. Quote, "Almighty God, we acknowledge our dependence on Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country." Unquote. This daily procedure was adopted on the recommendation of the State Board of Regents. The State Board of Regents is a governmental agency created by the state constitution to which the New York legislature had granted broad supervisory, executive, and legislative powers over the state's public school system. The state officials composed the prayer, which they recommended and published as part of their statement on moral and spiritual training in the schools. Shortly after the practice of reciting the Regent's prayer was adopted by the school district, the parents of 10 students went to the New York State Court insisting that the use of this official prayer in the public schools was contrary to the beliefs, religions, or religious practices of both themselves and their children. Among other things, the parents challenged the constitutionality of both the state law authorizing the school district to direct the use of prayer in public schools and the school district's regulation ordering the recitation of this particular prayer on the ground that these actions of official governmental agencies violated the First Amendment, which commands that Congress shall make no law respecting an establishment of religion, a command which was made applicable to the state of New York by the 14th Amendment of the Constitution. The Supreme Court, in a 6-1 decision, held that school-sponsored non-denominational prayer in public schools violates the Establishment Clause of the First Amendment. Justice Hugo Black delivered the opinion of the court. The opinion reads, by using its public school system to encourage recitation of the Regent's prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause. Justice Black then ventured into the history to discuss the role of religions in American history. Black wrote, it is a matter of history that this very practice of establishing governmentally composed prayers for religious services was one of the reasons which caused many of our early colonists to leave England and seek religious freedom in America. The Book of Common Prayer, which was created under governmental direction and which was approved by Acts of Parliament in 1548 and 1549, set out in minute detail the accepted form and content of prayer and other religious ceremonies to be used in the established text-supported Church of England. The controversies of the book and what should be its content repeatedly threatened to disrupt the peace of that country as the accepted forms of prayer in the established church changed with the views of the particular ruler that happened to be in control at the time. Powerful groups representing some of the varying religious views of the people struggled among themselves to impress their particular views upon the government and obtain amendments of the book more suitable to their respective notions of how religious services should be conducted, in order that the official religious establishment would advance their particular religious beliefs. Other groups lacking the necessary political power to influence the government on the matter decided to leave England and its established church and seek freedom in America from England's governmentally ordained and supported religion. It is an unfortunate fact of history that when some of the very groups who had most strenuously opposed the established Church of England found themselves sufficiently in control of colonial governments in this country to write their own prayers into law. They passed laws making their own religion the official religion of their respective colonies. Indeed, as late as the time of the Revolutionary War, there were established churches in at least 8 of the 13 former colonies and established religions in at least 4 of the other 5. But the successful revolution against the English political domination was shortly followed by intense opposition to the practice of establishing religion by law. This opposition crystallized rapidly into an effective political force in Virginia, where the minority religious groups such as Presbyterians, Lutherans, Quakers, and Baptists had gained such strength that the adherents to the established Episcopal Church were actually a minority themselves. In 1785 to 1786, those opposed to the established church, led by James Madison and Thomas Jefferson, who, though themselves not members of any of these dissenting religious groups, opposed all religious establishments by law on grounds of principle obtained by enactment of the famous Virginia Bill for Religious Liberty, by which all religious groups were placed on equal footing as far as the state was concerned. Similar through less far-reaching legislation was being considered and passed in other states. By the time of the adoption of the Constitution, our history shows that there was a widespread awareness among many Americans of the dangers of a union of church and state. These people knew, some of them from bitter personal experience, that one of the greatest dangers to the freedom of the individual to worship in his own way lay in the government's placing its official stamp of approval upon one particular kind of prayer or one particular form of religious services. They knew the anguish, hardship, and the bitter strife that could come when zealous religious groups struggled with one another to obtain the government's stamp of approval from each king, queen, or protector that came to temporary power. The Constitution was intended to avert a part of this danger by leaving the government of this country in the hands of the people rather than in the hands of any monarch. But this safeguard was not enough. Our founders were no more willing to let the content of their prayers and their privilege of praying whenever they pleased be influenced by the ballot box than they were to let these vital matters of personal conscience depend upon the succession of monarchs. The First Amendment was added to the Constitution to stand as a guarantee that neither the power nor the prestige of the federal government would be used to control, support, or influence the kinds of prayer the American people can say. That the people's religions must not be subjected to the pressure of government for change each time a new political administration is elected to office. Under that amendment's prohibition against the governmental establishment of religion, as reinforced by the provisions of the 14th Amendment, government in this country, be it state or federal, is without power to prescribe by law any particular form of prayer, which is to be used as an official prayer in carrying on any program of governmentally sponsored religious activity. Neither the fact that the prayer may be denominational neutral, nor the fact that its observance on the part of the students is voluntary can serve to free it from the limitations of the Establishment Clause, as it might from the Free Exercise Clause of the First Amendment, both of which are operative against the states by virtue of the 14th Amendment. When the power, prestige, and financial support of government is placed behind a particular religious belief, the indirect coercive pressure upon religious minorities to conform to the prevailing officially approved religion is plain. But the purposes underlying the Establishment Clause go much further than that. Its first and most immediate purpose rested on the belief that A union of a government and religion tends to destroy government and to degrade religion. The history of governmentally established religion, both in England and in this country, showed that whenever government had allied itself with one particular form of religion, the inevitable result had been that it had incurred the hatred, disrespect, and even contempt of those who held contrary beliefs. That same history showed that many people had lost their respect for any religion that had relied on the support of government to spread its faith. The Establishment Clause thus stands as an expression of a principle on the part of the founders of our Constitution that religion is too personal, too sacred, too holy to permit its unhallowed provision by a civil magistrate. Another purpose of the Establishment Clause rested upon an awareness of the historical fact that governmentally established religions and religious persecution go hand in hand. The founders knew that only a few years after the Book of Common Prayer became the only accepted form of religious services in the established Church of England, an Act of Uniformity was passed to compel all Englishmen to attend those services and to make it a criminal offense to conduct or attend religious gatherings of any other kind. A law which was consistently flouted by dissenting religious groups in England and which contributed to widespread persecutions of people like John Bunyan, who persisted in holding unlawful religious meetings to the great disturbance and distraction of the good subjects of this kingdom. And they knew that similar persecutions had received the sanction of law in several of the colonies in this country soon after the establishment of official religions in those colonies. It was in large part to get completely away from this sort of systematic religious persecution that the founders brought into being our nation, our Constitution, and our Bill of Rights, with its prohibition against any governmental establishment of religion. Therefore, the New York laws officially prescribing the Regent's Prayer are inconsistent both with the purposes of the Establishment Clause and with the Establishment Clause itself. Justice Potter Stewart dissented, arguing that no official religion was established by permitting those who want to say a prayer to say it. Stewart wrote, "With all respect, I think the court has misapplied a great constitutional principle. I cannot see how an official religion is established by letting those who want to say a prayer say it. On the contrary, I think that to deny the wish of those school children to join in reciting this prayer is to deny them the opportunity of sharing in the spiritual heritage of our nation." The court's historical review of the quarrels over the Book of Common Prayer in England throws no light for me on the issue before us in this case. England had then and has now an established church. Equally unenlightening, I think, is the history of the early establishment and later rejection of an official church in our own states. For we deal here not with the establishment of a state church, which would of course be constitutional impermissible, but with whether school children who want to begin their day by joining in prayer must be prohibited from doing so. Moreover, I think the court's task in this, as in all areas of constitutional adjudication, is not responsibly aided by the uncritical invocation of metaphors like wall of separation, a phrase nowhere to be found in the Constitution. What is relevant to the issue here is not the history of an established church in 16th century England or in 18th century America, but the history of the religious traditions of our people reflected in countless practices of the institutions and officials of our government. At the opening of each day's session of this court we stand, while one of our officials invokes the protection of God. Since the days of John Marshall, our crier has said, "God save the United States and this honorable court." Both the Senate and the House of Representatives open their daily sessions with prayer. Each of our presidents, from George Washington to John F. Kennedy, has, upon assuming his office, asked the protection and help of God. The second case of religions in public schools we look at here is Board of Education of West Community Schools versus Mergens. Westside High School was a public school that received federal financial assistance. The school permitted its students to choose from about 30 recognized groups and clubs on a voluntary basis. The students in all of those schools and clubs met after school hours on school premises. The school board had a policy about student clubs and organizations. School Board Policy 5610 recognized those student clubs as a vital part of the total education program as a means of developing citizenship, wholesome attitudes, good human relations, knowledge, and skills. School Board Policy 5610 also provided that each club shall have faculty sponsorship and that clubs and organizations shall not be sponsored by any political or religious organization or by any organization which denies membership on the basis of race, color, creed, sex, or political belief. School Board Policy 6180 on recognition of religious beliefs and customs required that students adhering to a specific set of religious beliefs or holding to little or no belief shall be alike respected. In addition, School Board Policy 5450 recognized its students' freedom of expression, consistent with the authority of the board. There was no written school board policy concerning the formation of student clubs. Students wishing to form a club presented their request to a school official who determined whether the proposed club's goals and objectives were consistent with school board policies and with the school district's mission and goals. In January 1985, a student met with her school principal and requested permission to form a Christian club at the school. The proposed club would have the same privileges and meet on the same terms and conditions as other student groups, except that the proposed club would not have a faculty sponsor. According to the student's testimony at trial, the club's purpose would have been, among other things, to permit the students to read and discuss the Bible, to have fellowship, and to pray together. Membership would have been voluntary and open to all students, regardless of religious affiliation. The school principal denied the request, as did associate superintendent. In February 1985, the principal and associate superintendent informed the student that they had discussed the matter with the superintendent and that he had agreed that her request should be denied. The school officials explained that school policy required all student clubs to have a faculty sponsor, which the proposed religious club would not or could not have, and that a religious club at the school would violate the Establishment Clause. In March 1985, the student appealed the denial of her request to the Board of Education. but the board voted to uphold the denial. The student and her parents then brought this suit to the U.S. District Court for the District of Nebraska. They allege that the refusal to permit the proposed club to meet at the school violated the Equal Access Act. The case went all the way to the U.S. Supreme Court. The court, in an 8-1 decision, held that an equal access policy would not violate the Establishment Clause. The equal access policy would have a secular purpose, would not have the primary effect of advancing religion, and would not result in excessive entanglement between government and religion. The court concluded that the school board violated the Equal Access Act by denying official recognition to students' proposed club. Justice Sandra O'Connor delivered the opinion of the court. She wrote, "The Equal Access Act provides, among other things, that a limited open forum exists whenever a covered school grants an offering to or opportunity for one or more non-curriculum related student groups to meet on school premises. Its equal access obligation is therefore triggered, even if such a school allows only one non-curriculum related group to meet." The school's denial of the students' request to form a religious group constitutes a denial of equal access to the school's limited open forum. Since denial of such recognition is based on the religious content of the meetings respondents wish to conduct within the school's limited open forum, it violates the act. If a state refused to let a religious group use facilities open to others, then it would demonstrate not neutrality but hostility toward religion. The Establishment Clause does not license government to treat religion and those who teach or practice it, simply by virtue of their status as such, as subversive of American ideals and therefore subject to unique disabilities. Justice John Stevens pointed out in dissent, the inquiry with respect to coercion must be whether the government imposes pressure upon the student to participate in a religious activity. This inquiry, of course, must be undertaken with sensitivity to the special circumstances that exist in a secondary school, where the line between voluntary and coerced participation may be difficult to draw. No such coercion, however, has been shown to exist as a necessary result of this statute, either on its face or as respondents seek to invoke it on the facts of this case. The third case on religion in public schools we look at here is Santa Fe Independent School District versus Doe. This case is about school district's policy on student prayer at football games. Prior to 1995, a student elected as Santa Fe High School's student council chaplain delivered a prayer over the public address system before each home varsity football game. Mormon and Catholic students or alumni and their parents filed a lawsuit challenging this practice and others under the Establishment Clause of the First Amendment. While the lawsuit was still pending, the school district adopted a different policy which authorized 2 student elections. The first to determine whether invocations should be delivered at games, and the second to select the spokesperson to deliver them. Through the elections, the students authorized such prayers and selected a spokesperson. The U.S. Supreme Court, in a 6-3 decision, held that the district policy permitting student-led, student-initiated prayer at football games violates the Establishment Clause. Justice John Stevens delivered the court opinion. Justice Stevens wrote, "Granting only one student access to the stage at a time does not, of course, necessarily preclude a finding that a school has created a limited public forum. Here, however, Santa Fe's student election system ensures that only those messages deemed appropriate under the district's policy may be delivered. That is, the majoritarian process implemented by the district guarantees, by definition, that minority candidates will never prevail and that their views will be effectively silenced." The whole theory of viewpoint neutrality is that minority views are treated with the same respect as are majority views. Access to a public forum, for instance, does not depend on majoritarian consent. That principle is controlling here. Such a majoritarian policy does not lessen the offense or isolation to the objectors. At best, it narrows their number. At worst, increases their sense of isolation and affront. Similarly, while Santa Fe's majoritarian election might ensure that most of the students are represented, it does nothing to protect the minority. Indeed, it likely serves to intensify their offense. The delivery of such a message over the school's public address system by a speaker representing the student body under the supervision of school faculty and pursuant to a school policy that explicitly and implicitly encourages public prayer is not properly characterized as private speech. For this reason, we now hold only that the district decision to allow the student majority to control whether students of minority views are subjected to a school-sponsored prayer violates the Establishment Clause. A dissenting opinion was written by Chief Justice William Rehnquist, joined by Justices Antonin Scalia and Clarence Thomas. Chief Justice Rehnquist wrote, "The tone of the court's opinion bristles with hostility to all things religious in public life. Neither the holding nor the tone of the opinion is faithful to the meaning of the Establishment Clause, when it is recalled that George Washington himself, at the request of the very Congress who passed the Bill of Rights, proclaimed a day of public thanksgiving and prayer to be observed by acknowledging with grateful hearts the many and signal favors of Almighty God." In this video, I discuss the role of religions in public schools in the United States. I also introduced 3 U.S. Supreme Court decisions. The Engel versus Vitale decision is about prayers in public schools. The Mergens decision is about equal access. The Santa Fe decision is about a school district decision to allow the student majority to control whether the student minority views are subjected to a school-sponsored prayer.